We'll stay with us and speak to Chris Oxtoby, Freedom Under Law Research Consultant. Chris, good afternoon to you and thank you so much for your time. Before we even get into the interviews that took place today, let's start with your reaction to the decision by Dr. John Klopper to withdraw from the JSC.
Yeah, I think it certainly took everybody by surprise. I think if one takes a step back to think of the original objections to his membership of the JSC in the first place, the fact that he had been removed from judicial office and was then potentially going to be in a situation where he was responsible for the appointment of judges, that was a significant concern. So I think it is the correct outcome that he has withdrawn, and that is, I suppose, something to be welcomed. Of course, there are a lot of unanswered questions in terms of what happens with ongoing litigation in the Western Cape High Court. It'll remain to be seen what happens there, and what indeed any other steps that his party may be taking regarding the interviews. But I think it is at least something to welcome that the immediate controversy about his designation to the JSC does seem to have been removed.
And how important will it be for Part B of that application, as you've just pointed out, to continue, in particular for matters of finality around some of the issues that were being raised and being dealt with for the first time, for example?
Yes, I think it will be. I mean, we were faced with a very unique situation of the designation of someone with that particular background to the JSC. So I suppose there is an argument to be made that that we should get a court decision on that issue. And of course, there are other questions relating to costs in the matter, which would still need to be resolved, and also relating to statements which have been argued to be contemptuous of the court process that were made by the MK party during the course of the litigation. So I think there probably are issues that would still be resolved, but look, we'll have to wait and see what the court wants to do with that, given that he has indeed resigned from the JSC since the litigation began.
The party is saying that it will not allow his name to be used to legitimize what it calls a patently misleading, fraudulent and improperly constituted JSC, and believes that without him, the body is violating the Constitution, particularly on issues around composition. What's your reaction to that?
I don't think that's correct. I think one has to look quite specifically at the circumstances under which this composition issue arises. And I think when we do that, it's very clearly distinguishable from situations that have arisen in past cases where the JSC has been found not to have a correct composition or a correct quorum. This particular scenario, there is a very good reason why that position is not being taken up, namely that there was a court interdict prohibiting it, and his resignation occurring during the interview process obviously makes it impossible for any replacement to come in before the interviews start. I would argue that puts it on a very different footing to a situation like, for example, the famous Cape Bar Council judgment, where the President of the Supreme Court of Appeal was absent for no discernible reason and no effort was made to find a replacement for them. I just think the situations are entirely distinguishable. There were good reasons why the JSC couldn't proceed with that particular member, and I think they did what they had to do in the circumstances. So I don't think that argument will fly as far as casting doubt on the validity of these interviews, but it remains to be seen whether there will be, in fact, be any challenge to that or not.
I'm keen to hear your thoughts on the interviews so far, especially given some of the issues that were raised today. You think about, for example, the land question popping up in one of the candidates there, saying that take race out of this particular issue, and that raising serious concern with others, but also, one who had hoped to get any position available. And certainly when you think about these things, there's a whole lot of focus on these interviews because we are expecting that the best of the best actually gets to sit before the JSC vying for some of these positions.
We are, absolutely. We definitely do want to see the best of the best. And I heard the previous interview before this, and I agree with what was said there. I think I see the glass been completely half full, but I certainly see some grounds for optimism. I think Judge Cowan is an excellent appointment as Deputy Judge President. I think she's eminently suitable for that position. I think the interviews have been largely conducted well. I think they've been rigorous, but they've been fair. I don't think we've seen the kind of bad treatment of candidates that we've seen during rounds in the past. I think there's always still ways in which the JSC can improve. I mean, you mentioned a candidate who was shortlisted for multiple vacancies despite not having had previous experience there. I think that immediately invites questions about the JSC's own process as far as shortlisting goes. If there was someone who seemed so clearly not to be considered appointable because they hadn't acted at a particular court, why were they then shortlisted for that court? So there's always going to be grounds for improvement. I think that's one that the JSC can certainly make. Whilst yes, there are some responses from some individual candidates that were not always the best and did raise concerns, I think it's also important to say that we did see some strong performances by some strong candidates.
True.
Let's hope that the rest of the week will be more of the strong candidates than the other.
And I want to stay with something you said briefly. That particular point around the processes and also the questioning is something that has come out in the past as well, talking about the issue around criteria, saying that you need to strengthen the criteria and tighten it so much so that there's no room for error. Do you think that has been addressed entirely over time, especially listening to what you've just said? And apart from that area you're raising, where should they be looking at tightening as well?
So the big question, particularly of relevance to freedom under law, is in relation to how the criteria are being applied to appoint particular candidates. So we've spoken already about some litigation. There's another piece of litigation which is ongoing over how the JSC, in a round of interviews last year, applied the criteria in selecting candidates for the Supreme Court of Appeal. And the challenge there concerns the question of, well, yes, you have these criteria that look very good on paper, but how is the process of applying them and making actual decisions on appointing candidates being done? And there was an argument that this was not rationally done during interviews in October last year. So I think that's clearly an issue where we have to continue to watch quite carefully how the JSC's decision making goes in the course of this week. One can have an interview where good questions are asked and candidates are treated respectfully, but the ultimate appointment decision might not appear to match up to the criteria. I wouldn't like to say anything too categorical about that point on this round of interviews where we're into our second day, and perhaps that's something that we need to look at and reflect on once this process is concluded. But that is definitely an issue I think that needs to be watched as far as the Commission's work going forward is concerned.
All right, certainly important reflections at the end of the process. Thank you so much, Chris, for your time. Appreciate it. That was Chris Oxtoby, Freedom Under Law Research Consultant.